In some situations, the police will respond to an incident. They will process somebody, they will make an arrest, they may draw blood, they may do interviews, but they won't actually charge somebody or file formal charges. So that person will end up leaving police custody without any paperwork. They won't have a court date, they won't have an MVD notice, they won't have any idea what's actually happening. This is more common than people think. And people will call our office and they'll say, hey, this whole thing happened. I was just processed by the police, but I don't know what to do about this. This can happen in many situations where the police are continuing their investigation. They're either doing some chemical testing on a blood sample, they're testing some contraband, they're doing interviews with other people who may or may not corroborate what actually happened during a 911 call. There's a lot of different reasons why the police can do an investigation but not have enough evidence to actually file charges, and they want to continue their investigation. We see this a lot in DUI cases where the blood results may take some time to be tested, then charges can be filed at a later date. So the question then becomes, how long do police have, does the prosecutor's office have, does the government have in order to actually bring those charges against an individual? Can they just sit out there forever? The answer is no. In law, there's a concept that's called the Statute of Limitations. This means that the government has to bring charges within a certain period of time or else they can't do it any longer. And so it's different for two different categories or classifications of crimes. Misdemeanors have a much shorter statute of limitations, and felonies have a much longer period of time. So in other words, for misdemeanor cases, they can't wait and wait and wait and wait. They have to bring charges much more quickly, whereas under a felony case, if you're going to be charged as a felony, they have a lot longer period of time. And so let's say something happened on day one under a misdemeanor case. They have up to 1 year from that day. So 1 year all the way around from the date of the incident. From the date of the incident, they have 1 year. So 1 year. That's the statute of limitations. If they wait a year and a day from the date of that incident, so if it happened today, we waited 1 year later, the following day, they could not bring any more charges. They could not file charges against that person because the statute of limitations expired. It's much, much longer in felony cases. This is the date of the incident plus 7 years. And felonies can be a little bit more complicated. There are some other exceptions that really don't have statute of limitations. They go on much, much longer from the actual date of the incident. Generally, this involves some sex crimes and things like that. But it's for most felonies, it's 7 years. And so you can see it's a much, much longer period of time. And it's important to know that. We've gotten many cases dismissed on that regard. So sometimes people will report late. Prosecutors' offices will just forget about filing charges. They will put it on their calendar. They'll file a day late or 2 days late. We've gotten cases dismissed literally because the charges were filed just a day late or 2 days late. They don't do that often, but it is something that's important. But really why this is more important is it helps give people a little bit of closure. That way you know that you're not going to be waiting around forever and ever and ever, especially if it's a misdemeanor case. If the case progresses past a certain period of time, say, for example, we know that blood is generally tested in 3 months, the case hasn't been filed in 6 months, it may be less likely that that charge is getting filed. If it's going 9 months, even better odds. If it goes a year and a day, they can no longer file charges against you anymore, and so that case is closed. Felonies are obviously a little longer. 7 years is a very long time to wait, but you also can have kind of the same process. You can have the same idea of whether or not these charges are going to be filed. If you're in this situation, that doesn't mean that you have to just sit around and wait. You can be proactive about it. We help people through this process all the time. We do what's called an investigation. So we don't have to sit around and wait until charges are formally filed. We can go and start getting police reports or accident reports. We can contact the prosecutor's office or the charging bureau with the county attorney's office and communicate with them and say, hey, what's going on? We know this incident happened. We believe that there's no evidence to support formal charges being filed. And so we can open up that dialogue and maybe even prevent charges from being filed and get some closure on the case prior to having to wait all this additional time. So I hope this helps explain that. It's something that for most people, the vast majority of cases, you're not going to be waiting around for the rest of your lives to see if they file charges. It has to be brought for misdemeanor cases, and like I said earlier, in most situations, it's DUI cases and domestic violence cases, have to be brought within 1 year. Felonies, it's 7 years unless it's kind of one of those exceptions. It's a sex crime or an underage crime or something like that. Hope that helps. If you have questions about it and want to speak to our office, speak to our team, speak to myself about it, give us a call. We offer free case evaluations. We can help you through it. Thanks for watching.